The purpose of the Flick-Reedy Education Enterprises is to promote individual moral responsibility through education. How do we do this? We study and discuss the interrelationships of history, philosophy, social studies, and economics. We do not dictate. We do not make statements as to what we think you should or should not do. We do not unduly burden this program with footnotes, references, or complete documentation. However, we do give sufficient data to bring this discussion into proper focus. We invite you to delve further into the necessary historical and statistical data to develop a deeper understanding of truth and a keener sense of individual moral responsibility.
It is interesting what the English statesman William Gladstone thought of our Constitution. In a letter to the Committee for the Centennial Anniversary of the American Constitution on July 20, 1887, he stated,
"I have always regarded that Constitution as the most remarkable work known to me in modern times to have been produced by the human intellect at a single stroke, so to speak, in its application to political affairs."
And now to have a bit of fun, as well as casting further light on men's belief that the Constitution provided a limiting power on government, we will hear some quotations from great Americans of many eras. See if you can remember or guess who said them.
The Constitution of the United States gives Congress no power to legislate in the matter of a great number of vital problems of government, such as the conduct of public utilities, of banks, of insurance, of business, of agriculture, of education, of social welfare, and of a dozen other important features. Washington must never be permitted to interfere in these avenues of our affairs.
Do you remember or guess this to be the statement of Franklin Delano Roosevelt while he was governor of New York State? Now, the next one.
Government is not reason, it is not eloquence, it is a force. Like fire, it is a dangerous servant and a fearful master.
Did you recall this as a quote of the father of our country, George Washington? Now the next.
The history of liberty is the history of limitations of governmental power, not the increase of it.
That was President Woodrow Wilson. How about this one?
The scarlet thread running through the thoughts and actions of people all over the world is a delegation of great problems to the all-absorbing Leviathan, the state. Every time that we try to lift a problem to the government, to the same extent, we are sacrificing the liberties of the people.
I'll give you a clue on this one. It was said in 1950 by a representative from Massachusetts. Yes, you got it. It was John Fitzgerald Kennedy. I hope that the foregoing materials have given you a feeling as well as specific information on the thoughts and deliberations that the Founding Fathers put into our written Constitution and Bill of Rights, plus some parallel thoughts by other great Americans in later times. Although the average age of the 55 delegates to the Constitutional Convention was a little above 40, they were a group of well-read men. Benjamin Franklin was the oldest, then 81. Dayton of New Jersey was the youngest, at age 27. James Madison was 36. Alexander Hamilton, 30. But almost all of them were students of history. There had been notable documents in history with which these Founding Fathers were familiar, and which exerted a profound influence upon them. We will review a few of the most significant of these documents. The first was, of course, the Holy Bible. That the Founding Fathers had spiritual convictions is shown earliest in the Declaration of Independence, then in their individual writings at various times. But it is apparent in the Constitution and Bill of Rights that they read the Scriptures deeply and thoroughly. Also influencing these men was the Magna Carta, perhaps the most important instrument in English history. Signed by King John at Runnymede in 1215, when a sword was placed at his throat by the nobles, the Magna Carta poked the first hole in the divine right of kings. It provided the restraint of written law and included 4 fundamental principles. 1. The king must rule, taking into account the rights and desires of the people. 2. Government is a contract between the king and the people, and neither one can break that contract without having to answer for it. 3. The arbitrary power of the king was restricted so that he could no longer rule by the whims and fancies of his mind. 4. The rights of Englishmen were specifically stated. For example, extraordinary taxes could not be levied without the consent of the representatives of the people. The next document of influence was the Petition of Right, presented to Charles I in 1628 by the English Parliament. It secured recognition of 4 principles. 1. No taxes without the consent of Parliament. 2. No imprisonment without cause. 3. No quartering of soldiers on the citizenry. 4. No martial law in peacetime. Certainly the British Bill of Rights was significant to the Founding Fathers. Accepted by William and Mary in 1689, it recognized the results of the struggle against the Stuart kings. Basically, it guaranteed the civil and political rights of the people and placed political supremacy in the hands of Parliament. Can you see how these various documents and the principles they contained were incorporated in the various sections of the U.S. Constitution? Our Founding Fathers were aware of the adage, "Those who are ignorant of history are doomed to repeat it." Next, let's look into some of the philosophers of colonial times whose writing influenced the thinking of the Founding Fathers. The noted English philosopher John Locke wrote 2 treatises on government, published in 1690. He proposed that the natural rights of man were life, liberty, and property. Does this have a familiar ring to it? Next, he maintained that in order to achieve good government, there should be 4 limitations on legislatures. 1. Legislatures must rule according to the laws of nature, God. 2. Legislatures must not transgress their own written laws. 3. Legislatures must not take property from an individual except with the individual's consent. And 4. Legislatures cannot transfer to another agency the power to make laws. Another philosopher, a Frenchman this time, was the Baron de Montesquieu, who wrote The Spirit of Laws in 1748. In this work he proposed the doctrine of the separation of powers of government as essential to the preservation of liberty. It is undoubtedly from de Montesquieu that our Constitution provides for the legislative, executive, and judicial branches of government. And finally, another Englishman, Sir William Gladstone, whose commentaries of the law of England became the basis for American law. His concept of civil liberty held the individual free to do right or wrong, but reaping the consequences of his wrongdoing as well as the rewards of his well-doing. He maintained that the purpose of society should be to permit every man to climb as high as he could under civil liberty. In addition to the influences of the historical documents and the previously mentioned philosophers, closer still to the Founding Fathers were their own colonial experiences. These lessons were to profoundly affect their writing of the new Constitution. One of these lessons was that the power of the executive should be limited. And along with that, the idea that the legislative branch of government should hold 2 basic powers. It should initiate the making of a law, and it should control taxes and money. Further from their colonial experiences, they saw the advantages of local self-government, placing great emphasis on the importance of the town and country and the important contribution and balancing power of each. The early state constitutions gave them much practical experience in many of the ideas derived from the philosophers. This practical experience included rotation in office, separation of governmental powers, the representative principle of government, guarantee of personal rights, and the source of all political power to be with the people. Overlying all these influences was a keen understanding of the nature of government and the nature of man. They considered government as possessing a great potential for evil, the taking away of the liberties of the people. Men have the governments they deserve because they have the governments they allow to exist. James Madison put it this way:
What is government itself but the greatest of all reflections on human nature? If men were angels, no government would be necessary. In framing a government which is to be administered by men, over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself.
In questioning why man had never before found a formula for government that would guarantee perpetual freedom, the Founding Fathers looked into the nature of man himself. They reasoned that the nature of government follows the nature of man, for man is always imperfect. Therefore, man can never create a perfect government. For government is nothing more than a few men ruling over many. Therefore, government contains all the potential for evil that is in man, multiplied by power. As Lord Acton put it so simply,
Power tends to corrupt, and absolute power corrupts absolutely.
What then can we summarize as the basic principles contained in our U.S. Constitution? First, perhaps, the system of checks and balances, provided by the separation of powers in the federal government, the legislative, executive, and judicial branches, and also the division of power between the federal government and the sovereign states and the people. Recognition of the supremacy of national law in those areas specifically delegated by the Constitution to the federal government. This, as you recall, was one of the failures of the Articles of Confederation. Next, we might list the limitation of federal powers to those so clearly defined and re-emphasized in the 9th and 10th Amendments of the Bill of Rights. Provision for judicial review is important as protection against unconstitutional laws taking away the freedom of the people. The Supreme Court and its branches were to provide a constant and impartial judgment, using the Constitution as the measuring stick. The amending process is important to us as the legal, constitutional means of changing or adding things which are felt necessary. Outlined in Article 5 of the Constitution, the amending process was designed as a somewhat lengthy process to prevent momentary impulses and hasty decisions from perverting the basic structure of our Constitution and way of life. I hope you feel a deeper understanding of the who, how, what, and why of our United States Constitution, that you've developed a closer kinship with those fine men who created it for us, and that all of us have an increased appreciation of what we started with way back in 1787. This does not presume that the Constitution is perfect, or that it never needs amending, but our appreciation of what went into it and why should cause us to look twice before allowing even well-meaning people to circumvent it or attempt outright usurpation of it. In concluding this brief study of our Constitution, I would like to share with you a part of Daniel Webster's eulogy of George Washington. He invokes a respect for our Constitution and issues a solemn duty in watching over it carefully. In words so beautiful as to bring tears to our eyes, he said,
If disastrous wars should sweep our commerce from the ocean, another generation may renew it. If it exhaust our treasury, future industry may replenish it. If it desolate and lay waste our fields, still under a new cultivation, they will grow green again and ripen to future harvests. It were but a trifle, even if the walls of yonder capital were to crumble, if its lofty pillars should fall, and its gorgeous decorations be all covered by the dust of the valley. All these may be rebuilt, but who shall reconstruct the fabric of demolished government? Who shall rear again the well-proportioned columns of constitutional liberty? Who shall frame together the skillful architecture which unites national sovereignty with state rights, individual security, and public prosperity? No! If these columns fall, they will be raised not again. Like the Colosseum and the Parthenon, they will be destined to a mournful and melancholy immortality. Bitterer tears, however, will flow over them than were ever shed over the monuments of Roman or Grecian art. For they will be monuments of a more glorious edifice than Greece or Rome ever saw. The edifice of constitutional American liberty.